House Bill 675 by Representative Glorioso provides relative to post-conviction relief, correction of illegal sentences, procedures, appeals, applications, motions, summary disposition, judgments, relief, claims, and duties. Mr. Speaker Pro Tem, on behalf of the Legislative Bureau, Representative Horton sends up technical amendments.
Without objection, Representative Glorioso.
Thank you, Mr. Speaker Pro Tem. Members, this is a bill that I was asked to bring on behalf of the Attorney General's office, and it addresses both procedural and substantive issues with the post-conviction relief system in Louisiana. I do have an amendment, if we can take that up.
Would you like to take that up at this time? Madam Clerk. Thank you.
Representative Glorioso offers up a two-page set of amendments at number 3330.
Representative Glorioso on your amendments.
Thank you, Mr. Speaker Pro Tem. Members, I've worked extensively on this bill with both the Attorney General's office, the District Attorneys Association, as well as the Innocence Project New Orleans. And these amendments represent mostly suggestions from the Innocence Project New Orleans that we have agreed to add to the bill. I believe it puts the bill in a better posture.
Is there any objection to the amendments? Seeing no objections, the amendments are adopted. Would you like to speak on your bill, or are you ready to take a question?
Absolutely, sure.
Okay, Representative Marcel with a question.
Thank you. Representative Glorioso, what is the estimated cost of this bill?
So the fiscal note we had in appropriations was, I don't have the exact number, but it was $4 million and some change.
I think it was 4.1 or something like that,
That sounds
right?
correct.
So is this something that we've already, and I think I asked you this in committee, is this something that's already been budgeted in the budget that we passed last week?
It is not. So this went to appropriations after the budget, so it is subject to appropriations.
So it's subject to appropriations. So have you all identified where these funds are coming from?
I have personally not, but I know the Attorney General has been in talks with the Governor's office and administration on funding sources, and so I think it's something that...
Got some idea where that's going to come from?
They have not given me that information, but it is subject to appropriations.
Okay, so we're going to increase the budget by, is it 8 million or 4.1?
4 million. So originally, that was before some of the other amendments we made prior to these amendments. And so they updated the fiscal note based upon changes that were made from when I originally submitted the bill to, I think we had done some amendments before committee even, or maybe the ones in committee. But there's already money that's allocated for post-conviction relief. And Chairman McFarland has been addressing some issues with trying to determine exactly which new monies are going to be required. And there is going to be some new money because of the expedited process for a lot of these petitions that have been sitting for a long time. So the organizations that handle these matters, which are mostly, we only fund these on the death penalty side. So the organizations that fund these or defend these matters based on state funding did indicate they would need additional staff because they're going to be required to move all of the pending petitions, that a lot of which have been laying dormant for quite a long time. And really that's the purpose of the bill, is to not have these shell petitions lying dormant for a long time. So I do believe in the short term there'll be a need for some additional funds for those, but in the long term, I think it's going to save us money because it's going to eliminate some of the pleadings that are filed solely to delay the process in the current system.
Okay, so the process that's laid out in your bill would actually expedite the post-conviction relief, would it not?
It would, yes. So, but like as you pointed out correctly, in the short term, it's going to require additional staffing. In the long term, I believe it will save us money.
Well, I didn't point that out. I said, will it actually change the process and make it more expedient?
Yes.
Post-conviction relief. That's kind of testimony that I heard.
Yeah, that is correct.
Is that accurate?
Yes.
Do you believe that this process somehow takes the discretion away from local judges and DAs to kind of manage their own dockets?
It absolutely does not. So that was one of the things that we worked with the DA's Association on, and they were insistent that they maintain authority. It does provide notice to the Attorney General's office, but the district attorneys still have the authority over these files. Now, they have the ability, if they choose, to ask the Attorney General for assistance, but that is up to the district attorney to make that decision.
Okay, so do you know the average rate for attorneys who represent post-conviction cases, relief?
So we only pay for attorneys in post-conviction cases, in death penalty cases. And so in every one of those cases, there are multiple attorneys that are being paid for by the state because of the lengthy and extensive appeal process and the post-conviction process. And so those are funded already. And so my understanding is everyone that's on death row is going to have probably multiple attorneys handling various aspects of the appeals process and post-conviction release process.
Well, are you aware that the rate for attorneys representing the death row prisoner in post-conviction is about $49 an hour?
The rate, okay, that was the testimony at committee.
Okay, and are you aware that the hourly rate authorized for contracting with the Attorney General is between $175 and $300 to $300 an hour? Do you see the big difference?
Yeah, so from committee, and again, I don't practice in this area, so this is all what I know is from committee. In committee, what we were explaining to us is that the groups that do the defense on the post-conviction relief, they get a lump sum every year to do this work. And so while they do submit timesheets, it's not necessarily like we would have a contract attorney in a civil matter where they're literally contracting at an hourly rate and billing. In this case, each organization is given a lump sum for all of the post-conviction relief, and then they allocate it within their own organization. I could be wrong about that, but that was my understanding of the testimony.
That was your understanding? So was your understanding also that post-conviction office in Louisiana spends about $1.2 million to represent more than 30 people?
I thought it was actually over $2 million that we spent, but you could be correct on that.
1.2.
Okay.
And the budget for the Capital Post-Conviction Office in Texas is over $3 million to represent fewer cases. I think that testimony came out as well. Are you aware of that?
I don't remember specifically, but I'm sure you're correct on that.
And do you believe that dollars should be in here for the Public Defender's Office in your bill?
So we do not provide attorneys in non-capital cases, as we're not constitutionally required to currently. So these cases are not defended by the Public Defender's Office. They're defended by specialty groups that are specialized in death penalty cases, and I think there's several of them. One of them came to testify in committee, but I believe there's more than that one.
And I know I was in and out of the committee, but I think I heard some testimony that this, if your bill passes, do you believe that it would rush through the process of post-conviction as we currently know it, and perhaps in rushing with these matters, that some innocent person may sit in jail longer?
I don't believe so, and that's why I've been working so closely with the Innocence Project. It is a highly technical bill to make sure that we were maintaining the protections we need to protect, but at the same time addressing the issue of shell petitions being filed and then being allowed to sit without being moved forward, and then used to delay and frustrate the judicial system, which is why in most of our death penalty cases, I think we have people on death row for 30, 40 years, and the victims are required to go back into court 7, 8, 9 times and relive the horrors of the crimes that were committed. So the process still maintains all of the protections and the rights to seek redress, but it does require that those files be moved and are not allowed to be just sitting there, and then it doesn't, that you're not intentionally delaying the
Right.
system without a real reason to do so. But I am cognizant of the issues to make sure that we're protecting the
Okay,
rights.
and you know, I guess my question would be, did any testimony come out that said that some of the delays that we all keep talking about were delays from not necessarily from the public defender side or the defense side, but from the district attorney side, that those cases have been delayed?
That wasn't my understanding.
That's not your understanding? So do you believe that in any of the cases where the delays are, do you think it's equal, or do you think that the DAs play any role in the delays in the post-conviction cases?
I don't have an answer to that. I would,
You know.
I would never want to say that the DA never plays a role in it, because I'm sure there are cases where there are, but I haven't been given any information specifically about where the delays are, other than in the multiple filings and then in the shell filings, which is the major issue we're trying to address.
Right.
But I'm certainly sure it could have occurred.
Okay, are you a criminal defense lawyer?
I do not do criminal defense, no. So
You're
I've
not
handled-
criminal defense?
I've handled a few cases in my 20-something years of practice, 25 years now, maybe less than 10 criminal cases.
Okay, so you believe that if this bill passes, it will help us to save money in the long term after we spend the $4.1 million?
Yes, I believe that because we're going to expedite these dormant cases, process them and resolve them, and then we'll have a more expeditious process going forward to make sure that the courts are addressing these issues, but they're not being allowed to be multiply filed and delay the system, that going forward, we won't have a system where we're paying multiple millions of dollars every year to a group of attorneys whose sole job it is to delay execution through filing anything that they can, and they're using that to frustrate the system. And so I think in committee, Chairman McFarland mentioned something like $20 million over the last, 8, 10, I don't remember how many years it was, that we've spent, and he asked the Attorney General, like, these cases are just being delayed, and it's true, because that's what their job is. The
Okay.
attorney's job is to delay this and use whatever tools they have without necessarily addressing the actual crux of the issue. We want them to get to the merits of the case in an expeditious manner.
I believe that both things happened, did you know? But let me wrap this up by asking you, this is your first term? Is this your first term?
That is correct.
Okay, so I was going to ask you, do you recall when Representative Terry Landry filed a bill to abolish the death penalty for a lot of the same reasons that you talked about, because nobody ever really gets convicted, is put to death here, and it would save us money. So you're not aware of the bill that, not this Terry Landry.
You had me confused there.
Terry Landry Sr.
Okay.
So some of the.
Not aware of that,
You're
no,
not
ma'am.
aware of it? Okay. And he raises a lot of the same issues that you raised in your bill, except he says that abolishing it would save the state money and get rid of a lot of the problems that we have. And did you have people come and testify? I know you had some victims that came and testified, but did you have anybody in opposition that testified that did not support your bill for reasons regarding the death penalty itself?
I don't recall anyone coming to the table, not on the bill, but about the death penalty in general. Maybe someone came in criminal justice, but I don't recall
I'm going to
that.
allow my other colleagues to speak, because I was on criminal justice when those bills were heard.
Right.
And a lot of, even the families didn't support the death penalty at that time. So thank you
Talking
very much.
about not my bill, but the other one.
No, not on your bill. Thank you very much. Thank you. I was just doing
Representative
the
Jordan
contracts.
with a question.
Thank you, Mr. Speaker Pro Tem. Rob Glorioso, so look, I got a couple issues with the bill, but I guess the biggest one is dealing with, the factual innocence, and if someone pleads guilty to a crime. Are you familiar with that aspect of your bill?
Yes. So let me address the plea of guilty issue first. We're working on, we have an agreement right now between the Attorney General's office and the Innocence Project to correct that. we thought that we had corrected it in this amendment set. I don't think we completed it, and so I have committed to them that we're going to correct that between here and the Senate committee. And the bill is going to state that if we're going to eliminate the prohibition if you pled guilty, because that the way it is in the bill now, in an amendment. We attempted. It was our intention to fix it in these amendments. As you can see, there's a lot of moving parts in this bill, but I have made a commitment to both the Innocence Project and I have confirmation from the AG to fix that issue. The other question you asked me was about
just factual innocence, but
my understanding, and I know you practice in this area a lot more than I do, but my understanding is that we have not abridged the ability to claim factual innocence in the changes that we've made to this bill.
you haven't changed it.
The member is out of time. I'm going to move to extend the time by 10 minutes unless there's any objection.
All right, so look.
No
if you-
objection. Please continue with your
No problem.
questions.
Thank you, Mr. Speaker Pro Tem. So look, I've worked with you enough. I know you're a man of your word on that. But I guess the question is, so those issues have not been completely formulated yet?
Well, I met with the Innocence Project at my district office in Slidell twice, and then we actually had an attorney from them here today. So I thought we had addressed the issue that factual innocence remained as it does now, and the rights to bring those factual innocence claims have not been abridged. If there's something that's in the bill that you think is in some way impairing that we need to address, I'm certainly happy to work with you on it. But I had made a concerted effort to work with the Innocence Project to make sure that was protected and those claims were maintained.
No, all right. Look, I'll tell you, I'll probably vote against the bill in its current posture, but I do trust and hope that you continue to work with them.
I will.
Thank you.
Representative Villio with a question.
Thank you, Mr. Speaker Pro Tem. Thank you, Rep. Glorioso, for your bill. Contrary to what Representative Marcel said, are you aware that these boutique law firms, because that's what I generally call them, do not keep their time on the casework?
Yes, it's my understanding they don't submit time like I submit time to the 10th of the hour. They submit much broader, and I don't know to what level there's detail, but they're paid a bulk sum
That's
for the work
correct.
they do, and they are allowed to do the work that they deem fit within that.
Right. And are you aware that, generally speaking, there's a handful of cases, year after year after year, the same cases, that they will oftentimes do cut and paste pleadings and then get this bulk sum money?
Well, right, and that's one of the issues, that there's no incentive for them to resolve the case on the merits, because their goal is to delay justice through the death penalty, because they're opposed to the death penalty. So, and look, that's their job as attorneys.
I understand.
But they're frustrating the system, and that's what we're trying to say. Is like, let's get to the merits, and let's see if there's a claim, and if there is, we'll resolve it on the merits. But let's not keep paying you $1 million a year, every year, just to frustrate and delay the system.
Thank you on behalf of the victims. I appreciate you.
Thank you. Representative Phelps, do you have a question?
Yes, sir, thank you. Representative Glorioso, in the bill, where is it? I see we have on the note here that it actually prohibits criminals, and I'm getting down to the part where it would relieve from clogging the system with frivolous lawsuits. And I know we use the word frivolous very loosely in this building. So
I didn't hear the beginning of what you were saying.
in your bill, can you tell me where it attempts to address frivolous
Members.
lawsuits?
Hold on
Right.
just a second, Representative Phelps. If we could quiet down just a little bit so that we can hear.
So
Proceed.
it doesn't, I don't know if it uses those words, but there's multiple sections. So going
That
to-
would address that issue?
That's correct. So the expedited process that we're putting in place, and also the abandonment process. And so right now, you can file what they call a shell petition for post-conviction relief, which basically has no information in it, and let it sit, and then wait for the state to try to move on their case, and then bring it back again. And so they use it to frustrate the ability of the state to move forward by having these shell complaints just out there. And what we're saying is that when you file that post-conviction relief complaint, you have to move that complaint forward in a time period. You can't just let it sit there forever and then use it to frustrate the system. So we're creating a time period that prevents those shell petitions and requires the petition to contain the merits of the claim. Like we require in every other type of suit, you have to assert the merits in the petition. You can't file just a shell.
So reducing the time frame and having more information in there, or are we reducing the time frame of which is valid?
Well, right. The whole idea is that if you can file it, but you need to move it forward. So when you ask for the relief, you can't just let it sit for 10 years like is happening now. You need to move it forward in a reasonable time.
And that's the one that's being detained, the prisoner? Or the system?
Correct. The person that is filing the post-conviction relief would be
Okay.
incarcerated.
Okay, and I didn't know it worked like that, that's why I'm asking that,
Ma'am.
for that information. I am concerned about the budget. So we're talking 4.2 next year, not the year after. This is going to be in effect very quickly, looks like.
That's my understanding. I don't have the fiscal note in front of me, but my understanding is that it's going to be for the initial time period, because all of those old petitions that are out there that have just been sitting, they're going to be directed to move those forward. And so that's what they're saying. They're going to say, we need additional staff to move those forward, because right now we're only moving 10 forward a year, and maybe we have 30. And so if we're going to have to move 20 that have pending petitions, then we need more staff to do that.
So then the staff would be housed where? Where are we looking to hire more?
This is all
people?
within, these people are separate organizations, private organizations, that are funded through lump sum amounts from the state to provide post-conviction relief in death penalty cases only as required by federal law. So these are private attorneys that have a contract to receive funding, but it's a lump sum to do these cases, and they came to the table and said, if we're going to have to move these cases in a more expeditious process, we'll need more staff to do it in that timeline, and I believe that's how the fiscal office, in working with them, made the determination of the note.
So these would be organizations that we already utilize throughout the state?
Correct, that's right.
So,
They would just
and
need
that's
more people in the short term to move the petitions forward.
So, and that's in each region, so
That's
Caddo
my-
and North would already have someone in place that provide these services, they would just be expanding
Yeah,
their
so like maybe, I
manpower.
think, I'm trying to remember exactly, I want to say that the group that was at the table said they had 3 attorneys now, and maybe they needed 2 more attorneys, and they told us how many, they have X number of paralegals, and they would need a couple more of those. So they did outline like what they would need to do from a staffing standpoint in the short term to accomplish the requirements that we're setting forth.
Okay, and lastly, after that, still in the note, it actually says that the exact impact of the proposed law to district attorneys, the AG, but district attorneys expect that the increased workload could be absorbed by existing staff. I hear a lot about DAs needing more funding as it is now. So how would this expand their expenditures that we are not
Right, so we worked
funding?
directly with the District Attorneys Association, and they as a group indicated that they would be able to maintain this either internally with their existing staff and/or in cooperation with the Attorney General's office, who has agreed to assist them if requested. And so because of that cooperation and the District Attorney's review, I believe they indicated they would be able to handle it within their existing framework.
And if they cannot, then assistance will be,
The
they need to
Attorney
reach
General
out
has-
to the association and then to the,
No, this is on the, I thought you were asking me on the DA side. So the associations.
The local
those are
DAs, if
not
I
on the DA
understand.
side. Those are on the defense side, and those are private. On the district attorney side, who is the state side, they said they can handle it internally, but also the Attorney General has staff available to assist when requested.
okay, so in the case of some district attorneys not being able to absorb that cost, which I have in mind some that will not, but this is the association speaking for them all, will they have an opportunity, would they have to go through the DA's association to say, hey, we don't have enough funding for this? How would that happen?
They would go through the AG's office on that, and then the AG's office could assign them Attorney General's staff to assist. And the AG did come to the table and say that they were ready, willing, and able to do that.
Okay, thank you.
Representative Glorioso, there are no other questions. Would you like to close on your?
Thank you, members. I appreciate the questions. I also appreciate that many of you came to speak to me about the bill in advance. I know it is a very technical and complex bill, but I believe it is an important step forward for our state, and I would ask for your favorable passage.
Representative Glorioso moves final passage of the bill. As many of you are in favor will vote yea. Those opposed will vote nay. Madam Clerk, open the machine. Members, please vote your machine. Jordan, no. Desautel, yes. Almaday, yes. Boye, yes. Thompson, yes. Guyman, yes. Members, are you through voting? Eccles, yes. Members, are you through voting? Knox, no. Clerk will close the machine. 71 yeas, 26 nays. The bill is finally passed. Representative Glorioso moves to adopt the title and moves to reconsider the vote by which the bill finally passed. Lay that motion on the table, and without objection, so ordered. Next bill. Co-authors. Madam Clerk, would you open the machine for co-authors? Members, co-authors. Representative Cruz would like to be a co-author. Any others? Madam Clerk, will you close the machine? There are 15 co-authors. Next bill.